84 and 87. Don't interfere with the regulations to grant and settle the land. That was the purpose of the regulations, to dispose of and grant and settle the land. This third subclause of this, nothing in this Constitution, this was actually the purpose of this clause. This third subclause was the reason they put this in the Constitution. Nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Remember that word claims? That goes back to 1763 when they had the claims to the lands. They consolidated their claims and compromised them in a trust agreement in 1780. The states still had claims to use that proceeds to pay the debt and to only create distinct republican states and no other purpose. Federal government had claims on that to pay the debt of the war. That was the whole purpose of Article 4, Section 3. Well, how do we know that? Maybe Ivory's just making this stuff up. Well, you see there's the constitutional debate where they told us what they were talking about and why they were talking about it. In the constitutional debate, you've got James Wilson. He's the only one who is the signer of the Declaration, signer of the Constitution, original member of the Supreme Court. He's the only one in that category. He says, there's nothing in the Constitution affecting one way or other over the claims of the U.S. on these western lands, and it was best to insert nothing and leave everything on that litigated subject to the status quo. You see, we've been resolving that among our states for years now. We don't need anything in the Constitution on that. That's an agreement that's already out there. Let's not even talk about it. Madison says, yep, I think you're right. Let's just be silent on the whole subject. But if we are going to say anything, let's make sure that we don't just talk about the claims of the United States, but declare that the claims of the particular states also should not be affected. Because you see, the states had a claim that you only use that land to create distinct republican states and use the proceeds to pay the debt and no other use whatsoever. So Mr. Carroll comes up and he says, okay, let's put this language in there. Nothing in this Constitution shall be construed to alter the claims of the U.S. or of the states to the individual states to the Western Territory. And then Governor Morris, who was on the Committee of Style, they were the ones that worded things. They worded it that way, and they changed it just a little bit in our final Constitution. But that's what they were talking about. You see, we've already resolved this. So all we're going to do in Article 4, Section 3 is say, let's not interfere with that trust agreement that we've already put together. Now we know then, after the Constitution, then Georgia still ceded their lands after the Constitution. And they said the same thing in their deed of cession. Only to create new states, only to pay the debt, no other use or purpose whatsoever. That trust agreement is how our nation ever even got born in the first place. It would have died at birth if it weren't for that. And that trust agreement is what started and is the basis and the authority for this public lands question. Well, let's see if there's anything else that is consistent with that. In fact, everything is consistent with that. Everything, until you get to 1976, is consistent that the federal government held the lands as a trustee. So this is Andrew Jackson. So think about this. By 1830, the debt of the Revolutionary Wars paid off. We have no national debt. It's the only time in our history. How would that be? Congress gets a bright idea. Because we have no national debt, we know we need to dispose of the land. That's the great national public trust, Henry Clay says in the debate. We got to dispose of the land. But since there's no debt, we're going to keep the money in Washington, and when the states do what we want, we'll give them some money. Does that sound familiar, Commissioner? Here's what he says. So it passes the House, it passes Congress, it runs right into Andrew Jackson. He vetoes the bill, and here's what he says in his veto statement. He gives the best history of what we've just been talking about, why the federal government ever held any claim, any title at all to those lands, and he writes a history. I've got a little handbook to here I can get to you electronically. I've got one copy I'll leave if anybody else wants a copy of this. We typically want to get $20 for those just so we can cover copy costs and keep printing them and getting them forward. But a copy of that's in here, it's online, and I'll send it to you electronically as well. Really recommend that you read this to get a fuller understanding. But here's just one little part of that. It's the real interest of each and all of the states in the Union, and particularly the new states. Who's he talking about here? Illinois. He's talking about Missouri. He's talking about Arkansas. He's talking about Florida. That the price of these lands shall be reduced and graduated, and after they've been offered for sale for a certain number of years, the refuse remaining unsold shall be abandoned to the states and the machinery of our land system entirely withdrawn. What would that look like today? Right? It cannot be supposed that the compacts, right, this 1780, and then the deeds of cession and the enabling acts of the new states, it can't be supposed that the compacts intended the United States would forever retain title to lands within the states that are of no value. You see, life, liberty, and property, health, safety, welfare within the states, that's the exclusive jurisdiction of the states. We never could have even supposed that the federal government would assert that we just keep that land within your state forever, except for what's authorized under Article 1, Section 817 of the Constitution. You know, forts, batteries, dockyards, and whatnot. That are of no value. No doubt it's entertained that the general interest, the interest of the whole nation, is best promoted by surrendering such lands to the states, where they can be productive and have a tax base to educate children and produce a vibrant economy. There's all kinds of things like this. What's interesting, you know, when you kind of lock in on something that you just know it's true, and then you keep looking and looking, and there's another thing and it supports it, and there's another thing it supports it, and there's another thing. Well, that's what we've been finding on this. You go back to 1780 and all the way forward. This is a Congressional Public Lands Committee report in 1828. This is because Illinois and Missouri and Arkansas and whatnot are 90% federally controlled, and they're taking that question to Congress and they're having hearings. Well, here's what they say. If these lands are withheld from sale, which is the effect of this present system, in vain may the people of those states expect the advantages of well-settled neighborhoods so essential to the education of their youth. See, we can't educate our kids if you're controlling 90% or more of our tax base. We can't grow our economy if you're doing that. Those states will, for many generations, without some change, be retarded in their endeavors to increase their comfort and wealth, because they have not the power incident to all sovereign states of taxing soil to pay for the benefits conferred. Look at that right there. They have not the power incident to all sovereign states. If you're a sovereign state, you have the power to tax. If you don't have the power to tax, you're something other than a sovereign state. What is that? I don't know. But you're something other than a sovereign state if you don't have the power to tax. When these states stipulated not to tax the lands of the United States until they were sold, they rested on the implied engagement of Congress to cause them to be sold in a reasonable time. We never said, oh, you just keep them forever and we'll never tax our land and you control all this land within our state. No, that was so contrary to the very principles and foundations on which our nation was established. No just equivalent's been given those states for surrender of an attribute of sovereignty. You see how critical that is? An attribute of sovereignty so essential to their welfare. This is Missouri. This is just one example of some of the resolutions. On the American Lands Council website, we're retooling the website to give you more easy access and one click, and you know, it's just kind of developed as a geek fest over the last couple of years. Oh, that's a cool piece of information, let's stick that on there. Oh, that's cool too, let's stick that on there. Oh, that supports it too, let's stick that on there. Now we're trying to go back and reorganize it and whatnot, but right now on the front of the website there's quick fact number 5. You can look at these original documents. You know, these resolutions, Missouri and Florida and Congressional Public Lands and whatnot. But look what they say. The present condition of the western states, this is Missouri, right? Says that a preservation of the present system manifestly appears to them to be an infringement of the compact between the United States and this state. Supreme Court's called it a solemn compact, something more than a contract. It's a solemn compact. And to not dispose of this land is an infringement of the compact. Missouri never could have been brought to consent to not tax the lands whilst they were unsold and not tax them for 5 years thereafter if it had been understood by the contracting parties that a system would be pursued which would prevent 9/10 of those lands from ever becoming property of persons in whose hands they might be taxed. Do you really think the founding fathers of Montana thought that Mineral County, we'd just say, you know what, you're going to have less than 10% taxable land forever, and we're going to bargain for that at statehood? They didn't do that. None of our states did that. Missouri didn't do that. Illinois didn't do that. But Illinois and Missouri and Arkansas and Indiana, Louisiana and Alabama and Mississippi and Florida understood what they meant, what those terms and documents meant, what the authority of the federal government meant, and they went to battle. We'll see that here in just a second. So here we go, right here. That read before the Louisiana Purchase and the Texas annexation of Guadalupe Hidalgo, well, from the Louisiana Purchase even, that red was all over that Middle East of our nation. It was 90% or more. It was all red. It was all red. Why the difference? What happened? Well, here's what's fascinating. As we dig into that and find out, it's one man. It's one guy. One guy. You know, sometimes we think, can I make a difference? Well, he did. One man. Those states were all 90% federally controlled for decades, and they were holding on to them just as tight as they are today. And say, oh, no, we're just going to keep these. And he says, no, you're not. And went back to educate, and we'll look at it. His name's Thomas Hart Benton. He was a Democratic senator from Missouri. In fact, his courage is so legendary, he's featured in John F. Kennedy's book, Profiles in Courage. He's one of the half a dozen or so people in that book. But here's what he says. He says, my election to the Senate found me doing battle for an ameliorated system of disposing of the public lands. You see, so often today, we think we have to fight against somebody, or we have to fight against something. He says, no, I went to battle for opening up my land so I can educate my children and better care for them and grow the economy in my community. And he said, I did that in a bill. He said, I resolved to move against the whole system. I did it in a bill that I renewed annually for a long time. I mean, he knew Congress was impossible. Does that sound familiar? He knew it was impossible, so he just ran the bill every year and he would educate in Congress, but more so he went to the people, because you see, in a Republican form of government that we have, knowledge and courage of the people drive the policy. That's how it works. The knowledge and courage of the people in a republic drive the policy. So he says, I ran a bill every year, but he said it was more so the speeches that had effect on the public mind, more so than the federal legislation. Because he got the people to understand knowledge and courage. Let's see what else he has to say. He says, these new states of the West, again, who's he talking about here? Illinois and Florida and Indiana and Louisiana, right? These new states of the West, they were sufferers by this federal land policy. Congress was less heedful of their wants and wishes. Does that sound at all familiar? They were like a stepmother, the federal government, instead of a natural mother, and became the monopolizer of the vacant lands of the West. And this monopoly, like all monopolies, resulted in hardship to those upon whom it acted. Commissioners, does that sound familiar at all? You know, isn't it? I mean, history is so fascinating, right? It's the same questions, the same concerns, the same problems. Few or none of our public men raised their voice against this hard policy before I came into the national councils. My own voice was soon raised there against it. It's certain a great amelioration has taken place in federal land policy. The sentiment of Congress, but more so that of the public generally, became much more liberal in land alienations. You see, again, in a republic, the knowledge and courage of the people drive the leaders they choose to act for them. So here's what he says. He says, the members of Congress, and I would submit that the county commissioners and the city councilmen and the state representatives and senators and the statewide elected officials and the members of Congress from the new states should not intermit their exertions or vary their policy, but fix their eyes steadily upon the period of the speedy extinction of the federal title to all the lands within the limits of their respective states. Imagine if Illinois were still 90% federally controlled today. Louisiana, Florida, right?
Chicago.
Imagine how different that question would be, but they were. Today they're all less than 5% federally controlled because one man talked to another man and got to groups like this, and they got to other groups, and doors just started opening. Because they had the vision and they had knowledge and courage. Can you see that? That's what they did. Same, and you saw, right, Alabama, Louisiana, same promises of statehood as Montana. Illinois had the same promise of statehood as Oregon. Same terms. Why the difference? Knowledge and courage is what made the difference for them. Now, this isn't just ancient history, because in 1959, Hawaii was almost 100% federally controlled before they were made a state. Because what happened back in 1893, the industrial powers came and took the land away from the native Hawaiians and gave it to the federal government. They weren't happy about that. As they started moving towards statehood, the native Hawaiians, understanding what statehood was, and with knowledge and courage, drove their representatives and said, we're not going to tolerate them controlling all of our land. You got to dispose of all of our land. And because they mobilized knowledge and courage, this is their enabling act. This is 1959. Now I'm guessing one or two of you might have been around then. I'm not going to point you out. United States hereby grants to the state of Hawaii, effective upon its admission to the Union, the United States title to all the public lands. They controlled almost all of it. Title which is held by the United States immediately prior to its admission. Here you go. Take all your land. Why? They're a Western state. This is the real heart of it when you get down to the bedrock principles on what we're founded on. This is George Sutherland, and we're proud of him. He's our one and only U.S. Supreme Court judge from Utah. He says, man has three great rights: life, liberty, and property. You know that all the state constitutions at the time of the U.S. Constitution, that's what they all said: life, liberty, property. The U.S. Constitution, or I'm sorry, the Declaration was going to say that same thing, but they didn't want to confuse the slave question, so they said pursuit of happiness. But life, liberty, and property, they're so bound together as to be a single right, because if you give a man his life but to deny him his liberty takes away all that makes life worth living. If you give him his liberty but take from him the property, which is the fruit and the badge of his liberty, you still leave him a slave. Think about that for just a second, right? Commissioner, think about this, right? So, property, that's my being, myself, my body, my thoughts, my sweat, my labor. And if I can do that and I can keep what I do, so I'm not a slave, like he says, if I can keep what I think and what I do and how I act, and I can accumulate that, well, then I can acquire property. And the more property I have, the more choices I have, right? Now, government necessarily takes some of our choices away from us in the form of property. But the whole idea was to have as much choice as possible, because see what we can do with that. Commissioner, that mug right there is really pretty awesome. You know, I've wanted a mug like that my whole life. And, you know, I got this iPhone that's got this kind of fancy, cool little case on it, you know. I actually had the opportunity to show that to Justice Scalia. I'll tell you about that maybe. But if I were to trade, you know, I worked and used my sweat and my toil to accumulate this piece of property. If I were to give you this piece of property for that, would you be all right with that?
Yeah.
So if I give you that, now would you think you're better off if I gave you that for this?
Probably.
And since this is all I've ever wanted in life, I'm better off. Because it's even got something in it.
Yeah.
We're both better off. You see what we just did there? We just created wealth. That's the only way you create wealth. The founders of our nation, when they established our nation, they understood that. That if we have our liberty and our property, then we create wealth. Now think about this for a second. If I knew that Jennifer wanted that mug, and I'm the government, I just say, you know what, I'm just going to take that mug and I'm just going to give it to Jennifer over here. Are you wealthier?
No.
No. Is she wealthier? Maybe. Is she really? I mean, but if it keeps going that way, the only way she's going to keep getting more mugs, have we created more wealth? Did anybody else produce anything? No, I mean, it's just we just taken this one here and given it over. There's nobody else that's used their sweat and their toil and their liberty to create anything, and we've just taken from here and given it here. We didn't create any wealth, right? Now, I may choose just out of the goodness of my heart and say, you know what? I know you've wanted one of these all your life. I'm just going to give you that. Am I better off? Well, there's some reason I wanted to give it to you, right? I either have a friendship with you or just a charitable person. For some reason, I'm walking away going, I did a nice thing. I'm better off. Are you better off? Mm-hmm. We still created wealth, right? We still walk away feeling better off if I chose to give that to you. That's the basis of our society, right? That was the whole fun. That's why property is so important. That's why this makes no sense. In our nation, where that was the fundamental foundational principles of how we can govern ourselves, was property. This is what John Kenneth Galbraith had to say about it, world-renowned economist, talking about this federal land issue. Where socialized ownership of land is concerned, only the USSR and China can claim company with the United States of America. And think of he made that statement in the mid-'80s. Think of what's been happening since then. Is our federal government acquiring more land or less? Substantially more. Just like that thing back there, the access is getting closed up. We're having less and less liberty and access to property as we go. I just read an article last week that China has figured out, imagine this, they figured out that if they give the land to the farmers, they're more productive. It's pretty novel, right? If we give you the land, you're more productive. And so China's going the other way. And yet here, based on those principles and that life, fortune, sacred honor that got us here, we're going the other way. Well, there's something fundamentally wrong there, and it shows up just in that image. I mean, you look at that image, and that tells the whole problem. There's something wrong with that. Well, why the difference? This is just an example of some of the legal authority. In this handout we'll send you, there's a legal analysis done by the Federalist Society. 40,000 constitutional lawyers, scholars, professors did a full legal analysis of what we're talking about. But here's just some examples. Supreme Court in 1980 said these enabling acts are solemn compacts, bilateral agreements to be performed in a timely fashion with enforceable rights and obligations on both sides. Does it make any sense the federal government can just say, this is what we're going to do, and we know you're made a state, but tough? Doesn't seem to make sense. We'll look at some other authority on that, but at the time of our statehood, your state and mine, federal government only holds territorial lands in trust. There's that word again. For the states ultimately to be created. In 1845, when Alabama was still 90% federally controlled and they're having issues, they had a case that says, once the United States has fully executed these trusts, see they keep using that word, because that's what it was. The sovereignty of the states will be complete. They'll be on an equal footing. United States never held any municipal sovereignty, jurisdiction, or right of soil in the territory, except for temporary purposes to execute the trust. See, it all starts back in 1780. The whole reason the federal government ever held title to lands other than forts, batteries, dockyards, arsenals, other needful buildings, the only reason they ever held title because we had to solve that question from the war. We had to figure out how we were going to break through that and not die in the infancy of our nation. And we solved that question. We created a trust so that it wouldn't get out of control, and the courts keep going back to that. Some people have said, well, after your statehood, somehow after your statehood, you just didn't want the land. You states just said, yeah, we don't want that land. Don't want all that minerals and timber, and we don't want to govern ourselves, because you see, with property and you have choices, then you can govern yourself. And for some reason they say, well, we just didn't want that after statehood. That makes perfect sense, doesn't it? Please go like this, right? Right? So by 1915, the Utah legislature passes a resolution, says you guys got to get on with your promise and go back to those compacts of disposing of the land, because we have less than 1/3 taxable land. By the 1920s, you now have Arizona and New Mexico. They were made states in 1912. They're all starting to get together and say, you got to keep your promise. President Hoover convenes a commission on disposing of the public lands. That leads to congressional hearings. And I don't know if you can see up the top there. The title of the congressional hearings in 1932, it says, granting remaining unreserved public lands to the states. Not if, just how. Now, your senator, and I can't, what's his name? Your senator that was chairing the, senator from Montana chaired the committee on this. I can't remember his name. I'll find it.
No, it was a long time ago.
This is 1932. I don't know. Has Tester been in that long?
It feels that way.
1932, right? So they're holding these hearings on granting remaining unreserved public lands. Now the administration, the agencies, they put up their own bills and they put up their proposals. Their proposal that they put up was, we're going to give you all the land. We know we've got to do that. Great national public trust, and they talked about the history back to 1780 and all the rest. We're going to give you all the land. We know we got to do that. We're just going to keep all the minerals. And so in the middle of the Depression, the western states all banded together, descended on Washington, and said, no, you're not. That doesn't work for us. You've got to keep the whole promise just like you did with all states east of Montana. And they killed that bill. And so some people take that and say, oh, you didn't want your land, right? Give you a false promise that you don't want, and therefore you don't want your land. No, they killed that bill, and so a year and a half later, they passed the Taylor Grazing Act as a stopgap to manage the lands. Now, some people said, well, the Taylor Grazing Act, somehow that's where you gave up your land, because that's the precursor to the BLM, and so somehow you gave up your land then. Well, look at the first line of the Taylor Grazing Act. In order to promote the highest use of the public lands, pending its final disposal. You see, it's consistent all the way from 1780 through the Constitution, through the 1830s when they were talking about that, through our enabling acts that say 5% of the proceeds of the sale and until title shall be extinguished. You see, it's all consistent all the way through until you get here. So in 1976, Congress says, well, we've got a new policy. And they don't mention the compacts and the Constitution in the background. And they don't mention Illinois and Missouri and what they did. And they don't mention the enabling acts. They just say, we have a new policy. We're just going to retain these lands in federal ownership. Unless it's in the national interest to dispose of it. We're just going to keep it. Now at that time, they also said in the Federal Land Policy Management Act, Commissioner, if you had all your land, you'd be able to tax it. You think that'd be a good thing? Would it be better than it is now? If you had the ability to control that land and generate revenue from it? Well, instead of allowing you to do that, since we're going to keep it, we're going to give you payment in lieu of taxes. That if you governed yourself and if we kept the promise, you would be able to generate taxes and govern yourself. But we're going to give you payments in lieu of taxes because, dear Commissioner, You like 13 cents more than $1, don't you? You'd rather have 13 cents instead of $1, wouldn't you? Because that's what PILT is. PILT's about 13 cents on the dollar, on average, of what you'd get if you could govern yourself and control your land and have that access to liberty and property. And so on that promise of 13 cents on $1, they also said that you know, if you could control your own timber, I'll show you some things in a minute that shows how states are way more effective at managing timber economically and environmentally than the federal government. If you did that, you'd put money right into schools and you'd put money right into roads. Well, we're going to curtail that, and we're going to give you a promise called Secure Rural Schools. And we're going to pay you to not use your timberlands, and to give you that promise. And then we're also going to say, you know, your minerals, you remember North Dakota to your east? And they get 100% of the mineral royalty, and they get to govern themselves, and they get to control their own property and have more choices. And they keep 100% of the mineral royalty from what they develop. Well, we're going to give you 48%. We'll give you 48 cents on the dollar because, yeah, it's better than 13. So we'll give you 48 cents on a dollar. But here's what we're going to promise you in FLPMA. You're going to have multiple use, sustained yield of your resource, and you're going to have local planning. How's that working out? You had any lawsuits on your resource management plans? We've had them ever since. You know, you do the resource management plans, they've been in litigation ever since. But that was the promise. So now here's what opened the door, okay? In 2009, unanimous Supreme Court case. What we discovered in Utah, we're $5 billion below average, or $5 billion of our total funding comes from the federal government. You guys are 42% dependent on the federal government for your total revenue. We're 45. We're $2.6 billion below average in per pupil funding. You're never going to tax your way out of those. We knew we had to look at this public land question and figure out how do we get to and. How do we develop the resource and protect the environment? Because like your governor said, it's an environmental emergency right now. How do we get to and on that? And as we're looking at that question, the director of our school trust land said, you know, there's a Supreme Court case that's just a couple years old, unanimous. And we looked at this language. Now, remember the background from Hawaii? Remember Hawaii, 1893? They took the land and gave it to the industrial powers. They gave it to the United States. They're made a state. They gave all the land to the state of Hawaii, right? So now fast forward to 1993. 100th anniversary of taking the land away. U.S. Senator Daniel Inouye runs an apology resolution to the Native Hawaiians. And he says, you know, whereas we apologize to the Native Hawaiians. Nothing in this resolution will disparage any of your claims to this land against the federal government, right? He does that like 30 some odd years after their statehood, after their solemn compact of statehood. He does this resolution. A couple years after that resolution, the state of Hawaii goes to sell some of its land. The Native Hawaiians now, based on this resolution, said we've got a lien right in this land now. Based on this subsequent unilateral act of Congress, we have a lien right in that land, over and above the Statehood Act and whatever. They take the case to the district court dismisses the case. They go to the Hawaiian Supreme Court and they uphold the case. Goes to the United States Supreme Court on that question. Here's what they say. The consequences of a state's admission are instantaneous. And it ignores the uniquely sovereign character of that event. Think about that language. I mean, that's the Supreme Court. That's not just words they picked out of the air. Those are pretty powerful words. It ignores the uniquely sovereign character of that event to even suggest that somehow subsequent acts of Congress can diminish what was already bestowed. And that proposition applies with even greater force where virtually all of a state's public lands are at stake. Think about what they said. Congress doesn't have the authority unilaterally after the fact to just change that solemn act of statehood. Makes sense, right? If they could just unilaterally change that, what's the point in being a state? That's what the Supreme Court just said. That's what got us started. That's what got us going back and looking at this. Well, what is that uniquely solemn act? What is that act that Congress can't change on its own? And that's what we've been talking about to this point, right? The Solemn Compact that started in 1780, all the way through the court cases and the presidents and the Congresses and our Enabling Act and our statehood, and even after statehood. That's what we've been doing. Congress can't change that on its own like it did in FLPMA. That's where we started going down this road and looking at all this. So we end up passing a bill. The bill that I ran was called House Bill 148, Transfer of Public Lands Act. And here's how radical this is, okay? Keep the same promise with us that you kept with all the states east of us that have the same language in their statehood. See how crazy that is? Right? Just keep the same promise with us so we can educate our kids and grow our economy and protect the environment and get to some measure of energy independence. Just keep the same promise. That's the whole point. Now, in doing that, we made the choice to say, at this point down the road, we're 100 years and more into this, national parks, off the table. We're not talking about those. Congressionally designated wilderness, and you in this room know that congressionally designated wilderness is different than all the de facto wilderness that's out there. Congressionally designated wilderness, off the table. We're not talking about that. National monuments, off the table, except for the Grand Staircase Escalante, where President Clinton, without talking to anybody in Utah, locked up millions of acres and trillions of dollars in coal. We still want to have a discussion about that one. All the other national monuments, off the table. By our choice, right? By our choice. Military, tribal lands, Indian reservations, off the table. We're not talking about those. In the bill, I'm going to say this a couple times so that federal public lands become state public lands. Federal public lands become state public lands for multiple use. Right in the bill, carry over all the existing uses. Because if you just upset that apple cart after 100 years, there's a bunch of rights, vested rights and expectation, hunting, fishing, grazing, mining, access, recreation, that are there. We're public land people. If we were in 1889 and they'd sold off all the land and we developed differently, well, that's a different story. But we're not there. We're not going to unring that bell. This is where we are, and so we got to start with where we are. So all the existing rights come over. Let me just say it one more time. Federal public lands become state public lands. Multiple use, sustain, yield with local planning. Those RMPs, those resource management plans, we're working directly with our counties in Nevada and what Senator Fielder's doing to work from the ground up where you understand the conditions on the land with local planning and land being done at the state level. Is it going to solve all the problems? Of course not. Are you going to have frustration with the state? Yeah. What's new, right? But we'd much rather be doing that. You can certainly mobilize on your state capital and mobilize there than you can in Washington, D.C. when 532 of the people making the decisions have no connection to Montana. So that's the basis of the bill. In our bill, we set a deadline of December 31st, 2014. The reason we did that, if you're in a negotiation and you don't have a goal that you're working toward, yeah, we'll talk to you tomorrow. Yeah, we'll get back to you on that. We set a deadline that we're working towards so that we could work on an orderly transfer with our federal governing partner. They haven't shown a real willingness to want to do that yet. So now as we get to that date, we start looking at what are our options if they continue to ignore us as a uniquely sovereign state, the Supreme Court has said. We start looking at our options, and there are legal options, there are political options, there are options